Coming to a recent judgment, that is Natco Pharma Limited versus Assistant Controller of Patents and Design. This was the judgment was given by Delhi High Court in 12th January 2023. Here, the petitioner is Natco Pharma Limited and the respondent is Assistant Controller of Patents and Design. So, recently this Natco filed a writ petition under Article 226 of the Constitution of India, assailing an order passed by Assistant Controller of Patent Design, allowing the Indian patent application filed by Novartis, that is respondent 2, on the aspect of procedural irregularity and violation of the principles of natural justice in passing of impugned order dated 14th December 2022. So the order is actually, the order states allowing the grant of Indian patent application filed by Novartis on 8th June 2007. This application is regarding Entresto, which is a blockbuster drug for treatment of heart by Novartis, and this patent is has already expired in the base patent of Entresto has expired in Jan 2023 recently. This is the current case is for the second patent of the same drug. So following a PCT application dated 16 January 2003, Novartis had filed a national phase application for grant of a patent titled Pharmaceutical Composition comprising Valsartan and NEP inhibitors, which was granted by Controller of Patent on 13 February 2009 as IIM 229051. This was the first patent. Subsequently, on 8th June 2007, Novartis had filed another national phase application for a patent titled Pharmaceutical Combinations of Angiotensin Receptor Antagonist and an NEP Inhibitor. So for this patent, the first examination report was issued on 30th January 2015. And after multiple round of amendment, the claim were reduced to 8 by May 2016. On 6 September 2016, Natco and other companies had filed a pre-grant opposition to application 4412 of Novartis under Section 25(1) of the Patents Act, raising various grounds to oppose Novartis' application. On 6th January 2020, Natco had filed an application before the controller in application of 4412 of Novartis, seeking to place the entire record of another hearing, that is CS 622019, before the controller. Novartis had acknowledged during that hearing that the invention forming the subject matter of the application 4412 had already stood claimed and protected in IIM-051. So on 7th May 2021, Natco applied to the controller for permission to cross-examine the expert that Novartis had filed affidavit for on 8th June 2020. The request was disallowed by the controller on 16th September 2021. So aggrieved by this judgment, Natco filed a case in Delhi High Court. So this case is regarding this judgment. So via judgment dated 12th July 2022, a coordinate single bench of Delhi High Court in the said decision asked the Patent Office to hear both the parties for 1 hour and to provide the final decision on the application or pre-grant opposition on or before 15th November 2022. The court also stated that the final decision rendered should be communicated to all the parties and to be uploaded on the website of IPO. The court specifically stated that proceeding in a pre-grant opposition and simultaneous examination of a patent application, however, cannot also result in a situation where the pre-grant opponent is kept in dark about the developments taking place in the examination process. So after this judgment, the chain of events that followed were Natco and Novartis were both heard by the Assistant Controller on 5th September 2022, and the matter was kept pending for orders. Despite the expiry of 15th November 2022 for passing of the said decision by Assistant Controller, no such decision was passed. 10 days later, on 25th November 2022, the Assistant Controller chose to send a notice only to Novartis, keeping Natco out of picture and calling Novartis to attend a hearing on 2nd November 2022. During the hearing on 2nd December 2022, the Assistant Controller intimated Novartis that he had already decided to allow claims 1 to 3 and claims 6 to 8. So on 14th December 2022, a written submission was filed by Novartis before the Assistant Controller without providing any copy to Natco, And on the very same day, the impugned order was passed, allowing amendment of the claims and granting the amended claims to Novartis. So Natco's argument is, Natco submitted that it was only after the impugned order came to be passed on 14 December 2022 that on 15 December, the notice dated 25th November, that is the controller asking the Novartis to come for a hearing, was issued by the assistant controller. The said notice was the notice to ask Novartis to come for a hearing, and the written submission dated 14 December, along with the grant of the patent to Novartis. Both the notices were displayed on IPO website on 15th December 2022. And no copy of the said submissions were supplied to the petitioner. So Mr. Sai Deepak, learned counsel of the petitioner, submitted that the grant of an opportunity of unilateral hearing to Novartis by the assistant controller on 2nd December 2022 by notice dated 25th November was not envisaged by any provision either in the Patent Act or in the patent rule. In his submission, Mr. Sai Deepak had referred to section 25 of Patent Acts and rule 55(5) of the patent rules. Novartis sides of argument were, Mr. Hemant Singh, the learned counsel for the respondent, stated that the amendment of claims in an application is an exercise between the applicant and the controller. On a conjoint reading,
another party was Novartis or the party office?
Novartis is the second party, like respondent. On a conjoint reading of section 15 and 80 of the Patent Act and rule 20, 28A and 55 of the patent rules, Mr. Hemant Singh submitted that the controller could take a decision to reject the opposition filed by the pre-grant opponent to the patent and thereafter allow amendments of the claims by the claimant, in which exercise the pre-grant opponent is not required to be involved. He further submitted that Natco can have no legitimate grievance as it was heard on multiple occasions and was granted a detailed hearing. The decision taken by the assistant controller consequent to the aforesaid notice, that is 25th November 2022, and the hearing that followed was only to allow deletion of claim 4 and amendment of title of claim 5. So the court's decision, the court noted that in principle of natural justice, especially audi alteram partem, requires hearing of both sides, wherein both parties should be involved in the proceedings at every stage. The court also noted that there is no provision either in the Patent Act or in patent rules which expressly envisages exclusion of the objector who objects to an application seeking grant of a patent at any stage of the proceedings. The court recorded that the right to oppose the grant of a patent is just as sacrosanct as the right to seek a grant of a patent. The public interest involved in ensuring that patentable inventions are patented cannot be accorded a greater degree of sanctity than the public interest involved in ensuring that the non-patentable inventions are not allowed to be patented. The court also referred to section 59 of the Patent Act, and that amendments is not a mere ministerial exercise, but seriously affects and results in civil consequences to the parties before the controller. Therefore, both parties must be heard before the amendment is allowed or rejected. The court observed that once the controller forms an opinion that the patent specification are required to be amended, communicates the said opinion to the applicant under Rule 55(3) under patent rules, and applicant files a response thereto under Rule 55(4), sub-rule 4, with a copy of the pre-grant opponent, Rule 55 sub-rule 5 comes into play. So Rule 55(5), sub-rule 5 requires the controller to consider the statement in evidence filed by the patent applicant, the representation including the statement in evidence filed by the opponent, and the submissions made by the parties, and if so requested, to hear the parties. As such, even at this stage, the statutory scheme envisages the hearing of both parties. So finally, the court held that the exercise that has been conducted by the assistant controller in the present case of issuing a unilateral notice only to Novartis, excluding Natco from the proceedings at that stage, and granting a unilateral hearing to Novartis without the participation of Natco, passing the order granting the patent, is alien to the scheme of Rule 55 of the patent rules and cannot be sanctioned by any provision of the Patent Act, as there is no provision in the Act which allows such procedure to be followed. The court concluded by remanding Novartis' application to the assistant controller for reconsideration, and the court also requested the controller to decide the matter himself or to assign this exercise to an officer other than the assistant controller who had passed the impugned order.